So we should be good to go now.
Okay, welcome, Councillor Oliver. You'll be pleased to hear you haven't missed anything because we've had some technical difficulties, and David is about to present the report. Thank you.
Chair and councillors, as Tony would have told you if his IT had been up to it, the government's brought in a new bit of legislation. It's quite time sensitive, which is why you've been asked to have this committee today, and why we're presenting proposed conditions, application form, and also requesting, as you'll see, your authority for delegated powers to officers in consultation as appropriate, and we'll get onto that bit. So the government has proposed a new, faster and cheaper way of having effectively a tables and chairs license. That is the placing of certain items, and certainly more than tables and chairs, on relevant bits of the public highway to assist businesses serving food and drink. The difference on the new legislation compared to the Highways Act 1980 procedure, which is obviously still valid, is that the consultation period is only 7 days, that's 5 working days. The application must be determined by the council within 7 days after that, again 5 working days. If not determined in the 14-day period, the licence is deemed automatically granted, and that's a big difference because that wouldn't be the case under the old Highways Act. The local authority can publish standard conditions that will apply to all licences, and indeed it's suggested that we do, because if you don't, then one of these automatically issued licenses will take free of anything you might want to add. The Secretary of State may set further nationally applied conditions. Your application fee drops to £100, which probably won't cover costs, but there we go. There's a power to revoke licenses, and also power to issue a notice requiring works of improvement, for want of a better phrase. And the licenses will expire on or before the 30th September 2021. So in paragraph 5, you'll see the furniture that may be authorised by this licence must be removable and is really quite wide. Counters or stalls for selling or serving food or drink. Tables, counters or shelves on which food or drink can be placed. Chairs, benches or other forms of seating. Umbrellas, barriers, heaters and other articles used in connection with the outdoor consumption of food or drink. Generally, I know you wouldn't be looking to license heaters, so there's an interesting business. Draft policy has been produced for your view and adoption if you like it, attached as Appendix A. Paragraph 3.3 sets out consultation requirements, and 3.5 and 3.6 sets out the matters that may be considered in determining the application and the possible outcomes. Appendix 2 lists the proposed standard conditions to be applied, and the draft policy indicates pavement licenses will only normally be considered appropriate between 0800 and 2300 hours. I would mention at this point that if a business has, in respect of the sale of alcohol, shorter hours than that, a pavement license won't be able to go beyond those hours. So if, for example, you're only allowed to serve alcohol till 8 PM, unlikely but possible, you can't be asking for a table license till 9. We've mentioned the automatic grant if not determined, and this short time frame, government imposed, means that the normal method of putting contested matters to your committee for your decision will not be workable, unfortunately. And therefore, in order to determine the applications within the relevant timescale, still allow robust scrutiny of the application and avoid automatic grant for non-determination, it's proposed that where there's no representations or concerns relating to the matter set out in para 3.5 of the policy, these will be determined by your licensing officers, licensing advisors. However, where there are representations or where there are concerns identified, these will be determined by the licensing team leader or manager after consultation with the licensing committee chair or vice chair. Unfortunately, due to the short timescale in getting this matter in front of you, there's been no opportunity to carry out public consultation on the content of the draft policy. And as Tony mentions in para 13, para 14, for the standard conditions to be applied to any licenses deemed granted, standard conditions need to be agreed and published before the application's made. Turning on to the pavement license policy itself, that hopefully is self-explanatory. You'll see the current fee is £467 if you wanted a Highways Act 1980 licence. Currently halved due to difficult circumstances, but as I say, the maximum fee the government allows for the pavement licence is only £100. So these should be very popular. Regarding eligible businesses, partial use is acceptable. So if a business isn't fully for the sale of food or drink, but partly for the sale of food and drink, they can still ask for a licence. It isn't all the highway that counts, only certain parts as per the Highways Act. And that might cause difficulty because frankly persons are frequently unclear as to the status of highway. Whether its footway is reasonably clear, but its status as pedestrianised may be unclear if there's significant access for servicing. But frankly, I wouldn't have to worry about that for the purposes of today's committee. The government has set out the bits of highway that count. As you say, 2.4 covers type of furniture permitted. 2.5 mentions that deemed planning permission to use the land for anything done pursuant to the licence will be granted whilst the licence is valid. As to submission of the application, you'll see the officers suggest the following will be required to be submitted: the application form, the fee of £100, a plan showing the location of the premises shown by a red line, and I recommend that you also require a plan showing precisely the area of highway the applicant is looking to have licensed. Otherwise, it may prove difficult to precisely identify the area. It suggested the positions and numbers of the proposed tables and chairs and logically any other items they wish to place on the highway as shown in the plan, and clear measurements are required. The proposed days of the week need to be mentioned in the application. The times of day need to be mentioned in the application. And in respect of the entirely feasible situation where an applicant wants to have the area to their front, but also perhaps to the frontage of other businesses in the vicinity, that is lawful because the applicant can apply for adjacent highway. And adjacent means more than directly next door to. But your officers propose that in that case, written approval is gained from the, and I suggest it's owner or occupier of the premises whose frontage is, as it were, being used. And the other matters are self-explanatory. You'll see there is the requirement for insurance at a value of 5 million for third-party and public liability risks. The council has determined the fee for applications will be £100, can't be more. And the council is required by law to consult with the Highway Authority. And it's also suggested there that others, including the Norwich Access Group, are consulted. And that will need to be done, obviously, within the 5 working days. So that will be quite a vigorous procedure. There needs to be a site notice, and the applicant needs, on the day the application is made, to fix and notice the application on the premises so that persons passing have an idea that the application is being made, and that must be maintained for the 7 days. Evidence the site notice requirement must be supplied to the council. Generally, as that will be supplied on the application date, I'd expect a photograph showing the site notice up to be provided. Then page 20, we've got what the site notice must contain, and a template is on your appendix 1. Then interestingly, 3.5, this is the site assessment, and an important bit of consideration. So public health and safety obviously will need to be considered, the latest guidance on social distancing, and that will be quite difficult because I think businesses will inevitably want to put quite a lot of tables on a limited frontage. So decent, competent social distancing measurements are going to need to be provided there. Crime and disorder, that's quite a tricky one. Will the proposed use have an impact on the likelihood of crime or disorder occurring? And I'm guessing your officers will obviously use their common sense and their local knowledge. Regarding public amenity, will the proposed use create nuisance to neighbouring occupiers by generating antisocial behaviour and litter? And again, a common sense view will need to be taken, and the views of local businesses might also be relevant there. If they say there's a current problem, logically the problem wouldn't be improved by the fact that the business in concern has a larger area to look after. Very important, accessibility, and inevitably taking a proportionate approach to considering the nature of the site. However, there will need to be maintained access. So I guess proportionate means hopefully a sensible balance is found between users of the highway, users of the footway, and the business wanting to try and remain functioning in this pandemic emergency situation. Determination, the authority will have regard to the Act, the regulations, the guidance, any objections made, the Human Rights Act, the Equality Act, any other relevant legislation or guidance. And obviously comments made by the Constabulary and the Highways, the Norwich Access Group, and any other relevant authority. I've not listed all of them, but they're there on page 21. Public sector equality duty mentioned. Most important, I would propose regarding access to be maintained. And the powers, again, page 21. The application can be granted in respect of any or all of the purposes specified in the application, granted in respect of some or all of the highway that was wanting to be used, impose conditions, or indeed refuse the application. I'm not aware of any appeal situation. Technically, I suppose anything can be judicially reviewed, but I should think it's very unlikely. License duration, it's a minimum duration of 3 months, and the expectation from the government is that the local authorities will be granting licenses for 12 months or more, unless there are good reasons for granting a license for a shorter period. As there is an ability to remove the license if there is a significant problem, breach of conditions, for example, then that long license should not be a difficulty. Delegation of authority, page 24, para 6. And as you'll see, there are 2 branches here. No relevant representations or concerns. The application will be determined by an officer holding the position of Public Protection Licensing Advisor. However, 1 para down, if there are relevant representations received, and there are concerns identified as detailed in para 3.5, then the application will be determined by an officer holding the position of either the Public Protection Licensing Team Leader or Public Protection Manager. However, before they do that, they'll need to have first consulted with the Licensing Committee Chair or Vice Chair. And as I say, that is not desirable, but it is necessary due to the very limited timescale the government has imposed on us. It's not clear that anything else is workable. Appendix 1 is the notice of application for a pavement licence, and Appendix 2 are the conditions. I do have suggested a couple of changes here. Proposed condition number 4 on page 26, instead of purposes stated above, because there aren't any, I suggest purposes stated in the licence. And in respect of condition proposed number 7, it refers to clause 13 when it should refer to clause 14. And I believe it would be sensible to add or early termination of the licence under section 6 of the Business and Planning Act 2020. Even though that is mentioned at the box on the top, I think it'd be also useful there to make it extremely clear to the holder that it can be taken away. Your officers somehow will also need to consider whether the application is in respect of highway of a status where the pavement licence can be lawfully granted. That may prove difficult, but it'll just have to be something the officers cope with. That's the end of the proposed presentation, Chair. I don't know if you have any questions for myself or Tony.
Okay, thank you very much, David, for that detailed presentation. Hopefully a number of questions, certainly some of mine, have already been answered, but I will ask members first of all a question, and then input where if there are any left.
Can't hear you.
I can't hear anything you're saying.
Can't hear you.
Okay, is that better? Okay, I had my papers over the mic. Apologies for that. Right, okay. Right, first of all, any members? I'll make a list and then we'll go around. I saw Councillor Fulton McAllister first, please. And then Councillor Price, Councillor Graham, Councillor Laura McCartney-Gray. So Councillor Erin Fulton McAllister first, and then we'll come to others.
Also, Councillor Oliver has a hand up, I think.
Thank you.
Yes, great. Cool. So 2 things from me. First of all, you have answered most of the questions that I had. Thank you, David. One amendment to make in paragraph 3.4, the final bullet point has incorrectly been numbered rather than bullet pointed. So if we can just get that changed to a proper bullet point, that would be good. That's on page 20. Is everybody seeing that? Yep.
Yep, thank you.
My only real remaining question, or I guess point, was about the standard condition number 19, which felt a little bit vague to me. I wasn't sure whether that refers to. So it reads, for licence areas used for the consumption of food or drink, the licence holder shall make reasonable provision for seating where smoking is not permitted. Does that suggest that they will be generally allowing smoking, but they're going to try and create some sort of bubble, or is it meant to be entirely non-smoking? I think that could do with some clarification. I'd quite like some clarity from officers as to the intention, and then you can decide.
Thank you for that, Councillor. Tony or David, did you get the gist of that question relating to the smoking areas?
I did, Chair. Thank you, Councillor. It's a direct lift from the legislation as to reasonable provision. And
what does it mean?
I guess it is, depending on the size, if you can, you should do so. So if somebody's got 2 tables, I would expect and hope that 1 table, and hopefully upwind, is non-smoking.
Okay. Are we able to add some words to clarify that? Because I'm not sure that it's clear at the moment, that it is intended to be partially non and partially smoking.
One option would be to lose the word reasonable, which departs from the government's proposals, but I think makes it clearer.
I would appreciate that. What do other councillors think? I think it's a good suggestion.
Yes, I think that's a sensible suggestion. So can we note?
Before I sort of take the officers to a position where they may not want to be, I don't know if Tony Shearman had a view on that.
Not a particular one. The requirement in the legislation is that there must be a condition that they must make reasonable provision seated where it's not permitted. The wording at the moment follows legislation which we would be departing from by removing the word reasonable. However, at the end of the day, I don't think it's going to matter that much. And there'll be, they'll only have one table and chairs. So therefore, they have to have half and half if wanted to provide for both. I can't see that there'll be a situation. So anyway, it's going to have more than one. So why they couldn't have some non-smoking and some.
Okay.
Okay, thank you, Tony. We're still having trouble hearing you, unfortunately. Right, okay, next I had
Yeah, sorry,
Price.
can I clarify then, what are we going for on that wording? You want to remove reasonable and replace it with, or just
remove it. So I think that would make the default, if you've got one table, it would be non-smoking, and if there are more than one, you can make some of them smoking.
Can I just
Yes,
have a
that
show of
sounds
hands,
correct.
everyone, about thoughts for that? In support of it, councillors?
Okay, is everyone in support of that, please? Please indicate. Yep.
Lovely, lovely, thank you.
Thank you. Okay, Councillor Price, please.
Thank you, Chair. It's excellent that we're considering this today. We need to support local businesses. At the same time, being a city centre councillor, I've got to also represent residents. And one of the issues that residents often raise with me is issues around noise nuisance emanating from late night economy, etc. Although we do need to support business, we need to be proportional in this. And so I do notice in the policy here that we're talking about potential issues of noise nuisance. We're going into the summertime months where we have older residents with young children. People will be having their windows open in exceptionally hot summer evenings, and suddenly we are potentially generating lots of additional street noise, and even without amplified music, and this can actually reach quite high levels. So my concern here is around that there is no provision for residents to raise an issue or a complaint after the granting of a license. There is no provision. There's talk about effectively officers potentially taking action against licenses, but there is no mechanism for residents. So I don't think that is a fair and just process. So I think that needs real consideration, because effectively we're locking residents out of dealing with the aftermath of the grants of these licenses. So I mean, I've got a couple of other points, but I'd be happy for discussion on that.
Chair, I don't know if it would help, but on page 23, one of the reasons why the authority can revoke a licence I see is noted as antisocial behaviour or public nuisance, increasing the amount of noise generated or litter not being cleared up.
There is no formal wording there, David, to suggest that if residents have an issue, that they have a mechanism to raise that issue, that officers have to listen to that issue and act upon it. It effectively completely disenfranchises local residents.
I agree, Councillor, as to the formality. I guess the intention would be that it would be raised with the licensing office, and then the officers, if you were happy to delegate the power to them as proposed, would then have the opportunity to consider those complaints.
Thank you for
that would need wording. That would need wording, wouldn't it?
I think,
Can I-
am I right in suggesting that there is provision within this to limit the times in consultation with the chair following representations from the public on this? While there is a wider time limit of 8 to 11, conditions can be imposed within that.
Chair,
Is
I'm
everybody
sorry, I'm
else struggling to
struggling.
hear Ian?
I think the chair said that conditions could be imposed, whereas it was perhaps standard to look at 8 to 11, it could be less, fewer hours, I beg your pardon, if appropriate. And I believe that is the case, yes. Though I'd be expecting that decision to be made at application determination stage.
Okay, I've changed my mic. Can anyone hear me now?
Yes.
Is that better? Thank you.
Yes.
Okay, I'll come back to Councillor Price, who wants to come back on that, please.
Thank you, Chair. Yes, I think what we're talking about is you've got the determination stage. You've made it clear that perhaps you can apply additional conditions, but you have no, in the policy, you have no formal written process for residents to engage. This is all completely ambiguous and at the discretion of officers and the chair to determine whether or not any action should be taken. This is completely different to any kind of other sort of license or noise nuisance situation that we have. It doesn't make it clear to residents that they can raise an objection, because at the end of the day we want to support businesses. But it's got to be done in a fair and proportional manner, and it needs wording.
Okay, I don't
Can I
have
make
any.
a suggestion?
Yes, please do.
Because I think it's a very good point you make, Ben. So under on page 23, section 5, bullet point number 2, after the word where, if we add something to the effect of where concerns are noted by relevant authorities or raised to council officers by members of the public. Yes.
Okay, thank you very much. Councillor Price is indicating he's happy with that. Everybody else, is that
okay?
Yeah, okay, everyone's indicating that.
David,
Okay.
David, have you got anything on that? Is that okay?
Sorry, I'd muted myself. Yes, I can see that wording should work.
Okay, thank you
Did
very
you get
much.
it down okay, Alex?
So, concerns raised by relevant authorities or members of the public.
Concerns are noted by relevant authorities or raised to council officers by members of the public, was the wording I had.
Okay, thanks very much. Does anybody else have anything to say on that particular issue? Councillor Maxwell.
Yes.
Thank you, Chair. Yeah, I do want to bring in what, before I start, I will say that I do live in St Benedict's. I haven't made any recommendations or complaints about this. But what I really want to get over is there wasn't a consultation. When it was put out, they only consulted the businesses. They didn't realise in St Benedict Streets there's 100 of people who live in courts off it or over the shops, none of which really did a consultation. I knew about it because I was on the City Council and we talked about it, and I didn't realise that one thing I found out, all the planning and all the planning to close off, to put the tables and chairs, was done off plan. They didn't realise that there were so many people living there. They also wanted to make the top of St Margaret Street, which is a one-way street. They wanted to close it off. And it's only when somebody got in touch with them and told them that they couldn't. Now, I don't think they've really thought out what should happen, because it's such a narrow road. And I think a lot of what we've got in here and what you've raised already this morning is going to be difficult to for the licensing people, because they automatically will have to go out into the road, anybody who's applied for a license, because the pavements are so full. And I just want to raise this as when we're thinking about what we're going to do. And the other thing is, of course, we've got so many people, and there's quite a lot of children down here in the flats. So I think that the late night opening up to 11 o'clock, I think that would go on to the early hours when we're clearing up. So I prefer to see a 10 o'clock close. I know the County Councillor, Danny Douglas, has been doing a lot of work on this with the county. And also the other thing we found out is that although we grant the licensing, it's up to the county to monitor it. And there's been 2 or 3 places already opening on the street with tables and chairs, and it's not been monitored by the county council. Danny has written to them. We got a reply from Graham Bygrave to say there was a confusion and now they're going to police it. Thank you for listening.
Okay, thank you very much for that. Yeah, clearly there are concerns relating to St Benedict Street. I think the proposal here is wider area.
I'm losing you
can
again,
hear
Chair.
me? Okay, I'll try another speaker. Okay, is that better? Can you hear me now?
Yes. Yeah.
That's
Okay,
much
thank
better,
you.
Chair.
Right. Okay. Thank you, Councillor Maxwell. I think one of the issues we have here is in some areas of the city, the 8 to 11 will be a suitable time for these tables and chairs, and in others it won't be. But the paper we've got in front of us allows us to set conditions in different parts. Tony or David will be able to correct me if I'm wrong, and it might well be that St Benedict's and other areas where we have a higher density of residential properties, it'd be suitable to have a shorter time period, or certainly a close. And when it says 11, that is when the tables and chairs will need to be removed and cleared away. So businesses will have to bear that in mind. So all items will need to be cleared by the period that we set, or the end of the day that we set. Okay, David, would you like to come back on that?
I wouldn't particularly, Chair, in preference to Tony, who I saw did have his hand up.
He did. Thank you, Tony.
Chair, can you hear me?
Unfortunately, we can't hear you, Tony.
Okay, hold on just a minute. No, but don't touch anything.
Right. Can everybody hear me now?
Right. Thank you. Yes, we can hear you now.
Right.
Go
okay.
ahead.
If I can just come back on a very valid point that Councillor Maxwell has made with regard to the time, when I originally drafted the policy before the legislation acted, did
No, unfortunately we can't hear you again, and your screen has frozen up. David, are you able to help us input onto this one?
I'm sorry, Chair, no, because I don't know what Tony would be saying about the hours. I mean, at the moment, will only normally be considered appropriate between the hours of 800 and 2300, we could add words to the effect of depending on area, thus making explicit what is currently implicit.
Tony, are you able to type what you were going to say into the chat function, and then somebody can read it out for the benefit of the screen?
No, I haven't got a keyboard.
If you say it, I think I can type it. Yeah, you need to be at a distance.
Okay, so meanwhile, we had a suggestion from Councillor Maxwell that we should limit the time to 10 p.m. If possible.
Ian, I can't hear you.
Right, this is okay. Can we? Can I suggest that we
possibly
take a
turn?
break?
Yeah, maybe try your without video points, Chair. It might catch up your stream, perhaps.
Okay, is that any better for anybody?
Yes.
Yeah.
It is. Okay, thank you. It appears I have a weak signal here. I'm actually in the middle of Yorkshire. Clearly not working very well. Okay, thank you. Yes.
Chair, that issue of the timing, Tony was saying the reason he changed it to 11 was another bit of the legislation about off sales for alcohol, but you can decide if you want to now around timing.
Okay, so that would allow operators to sell alcohol outside until 11 o'clock as off sales.
Yes.
Yeah.
And that was
Would they not ordinarily have that facility within their premises?
Chair, can everybody hear me okay?
Yes.
Yeah.
Yeah. Okay. So there's more than one part to this new piece of legislation. One part deals with these pavement licences. The other part deals with a relaxation of some of the licensing legislation. So some premises that might have an alcohol sales licence, which only allows them to serve alcohol for consumption on the premises, therefore wouldn't be able to use a pavement licence this licence wouldn't allow them to allow the sales of alcohol for consumption in the proposed pavement licence area. So another part of this new piece of legislation has introduced some relaxation on some of those alcohol sales to allow off sales where they wouldn't necessarily or normally be allowed. Now, that piece of legislation was, when it eventually went through the House of Lords curtailed it to an 11 o'clock finish. So, whereas previously the draft of the legislation, the way it was written, suggested that the off sales could be relaxed for 24 hours a day, House of Lords curtailed it to 11 o'clock to make sure that these extra facilities for people to consume alcohol in outside areas did have an end time. So that was the reason for bringing the policy with regard to the pavement licences in line with that other part of the Business and Planning Act. However, my view when I originally drafted it was that this potentially in some of the streets such as St Benedict's, where there's a large amount of premises and potentially a large amount of people on the streets, a 10 o'clock finish would have been potentially more appropriate in some of those circumstances, which is why I originally drafted it as 10 o'clock, but changed it to 11 just to bring it in line with the other part of the legislation. It's a matter for debate, and there's no reason why we couldn't curtail it further if we wish to.
Okay, thank you for that, Tony. Councillor Price, would you like to come in on that particular point?
Yes, thank you, Chair. Just really briefly, yeah, that's really the first kind of I've heard of it. So my sort of first question, really, to understand that is that these off sales, are they for the consumption in the designated outside areas, or are these for off sales to be taken out? My suggestion would be that one of my other questions is, although there hasn't been time for public consultation around this actual piece of legislation we're putting forward, have we actually had a consultation with the consultees? I would be concerned that if we were suddenly introducing off sales as a blanket opportunity associated with lots of additional licenses, where these are designed for people to go off and consume away from the premises outside designated area, could have a detrimental impact to certain things like public nuisance and antisocial behaviour. I'd be interested to know if the police are aware and have actually commented. The other point I would say is that I would, if there is wording around this, is that I wouldn't want to hold back businesses, but I would perhaps determine that these off sales need to be consumed in the outside designated areas unless pubs are subject to, these venues are subject to a lockdown situation. I did personally take advantage of sitting out in some of our public spaces and convivially having a few drinks, in a very sensible manner during that lockdown period, which was very beneficial. But because the actual venues are open now, I mean, I wouldn't want to create this kind of public situation. So I think for the off sale to take away should only be if you actually can't stay at the venue. That would be my view.
Chair,
So,
if I can.
So did we consult the police about this?
Chair, if you don't mind, I'll respond very briefly to that. No, we have not consulted with the police on this policy. However, I think what Councillor Price is referring to is the primary legislation change which allows these off sales to happen. That's not something that we have any policy control over. It's primary legislation, and therefore we cannot influence that. Obviously, the government would have been in consultation with various people when they introduced the legislation, but it's not something policy-wise we have any control over. Obviously, in the town centre, we do still have the PSPO, so anybody that is drinking in an area outside of a licensed area could be subject to enforcement action by the police.
Okay, thank you, Tony. Councillor Fulton McAllister had her hand up, and I'll come back to you, Councillor Price, in a moment.
Just on that, am I right in thinking that, so of course the PSPOs are still in existence, people can be moved on if they are street drinking, and if we become aware that a certain venue is the source of a lot of street drinking, under the policy in front of us, that could be a reason for revoking their new licence. Because they're creating nuisance, is that correct?
For alcohol licensed premises, there are a number of ways forward. Obviously, their premises licence can still be a review applied for if there are problems with the way that they are managing the alcohol sales. And yes, we still have, under the new Business and Planning Act and the pavement licences, we have the ability to revoke those licences for the outside areas if they are proving problematic in some way.
So if that's the source of new nuisance behaviour, and we have good reason to believe that, we can, under this new policy, revoke those licences.
Yes.
Okay, thank you for that. We need to tie this up, what we propose to do about the timings. So does anyone have any suggestions about adding wording, changing the timings right now so that we can move on to the next item? Councillor Price.
Thank you, Chair. Just briefly, so the point of clarity is that this, with Tony, is that this is primary legislation. So you're confirming that basically any pub, any licensed premises can sell alcohol currently under primary legislation to anybody as an off sales situation, and that this doesn't actually relate to off sales for sitting outside with the tables and chairs area. Is that right? So any pub can sell alcohol to take away. Is that right? That's the primary legislation as in existence at the moment. Fine. So we have no control over that. Thank you. I think
okay.
Yeah. That's fine. That's fine, Chair.
Okay, does that answer a question sufficiently? Councillor McCartney-Gray, please.
Hi, I've got some questions around accessibility, but I'll come to those later. I thought Councillor Maxwell was proposing reducing the times to 10 p.m. Is that right?
Yeah, correct.
So do we need to vote on that?
If that's a formal proposal, then yes, we would need to vote on that. Just before we do, Tony and David, that is something that we can do. Is that correct?
Yeah.
Yes, Chair, you're looking at a condition.
Okay, so all those in favour of adding a condition to reduce across the city to 10 p.m. in the evening, please indicate now.
It needs formal seconding first.
It does indeed, yes. Who would like to second that?
I'll
Councillor-
second.
Okay, okay, Councillor Maxwell, I think you were proposing that. Councillor Ackroyd, are you seconding? Yeah, thank you. Okay, all those in favour, please indicate. Okay, so we have Councillor Maxwell, Councillor Ackroyd, Councillor Price, Councillor Graham, Councillor Lauren McCartney-Gray, Councillor Huntley.
Thanks, Chair.
All those against? All those against? Okay. Oh,
Yeah.
I'm putting up the wrong hand. I'm in shot here. There you go. So that's Councillor Stewart, Councillor Fulton McAllister, Councillor Giles, and Councillor Oliver.
So we've got, oh, was that 4?
Yeah.
Yeah.
So is that carried?
Yes.
Yep, thank you. Right, okay, so that will be the new timing in our document. Thank you. Okay, so next on my list, I did have Councillor Graham. Do you still have a question, please?
Leslie, you're muted.
Mike.
Thank you. Most of my questions have been answered, but I still have 3 outstanding. One is about public engagement, because if residents have a concern, they're likely to come to their councillors. They're less likely to raise it if we say, well, you have to go to the officer. And I'd like to remove that barrier, which we could perhaps do by adding to the change that we made earlier, where residents or councillors raise issues with officers. My second point relates to access. There's some really good things in there about access, but I'm a little bit, but I just want to flag them up and make sure that businesses, that they're spelt out to businesses, so that they're not failing because they just didn't notice because they've got so much else on their plate. And the third thing I wanted to raise was, if we have a lot of places putting patio heaters out, we're going to have a lot of problems with the heat, with the carbon, when we're trying to go in the opposite direction. And I think we could save ourselves a lot of conflict if we just remove the patio heaters from the list of furniture that's allowed. Thank you.
Okay, thank you. Can Tony, could you respond to that, please?
Yes, Chair. With regard to the patio heaters, we can remove that from the policy. I would also suggest replicating the standard condition that we have on our normal table and chairs licences that says something along the lines of, this is just for the tables and chairs. It does not include things like patio heaters. So it would include a specific condition that says you may not have patio heaters.
Yep. Everyone is everyone in favour of removing patio heaters from the equation?
No. Yeah. Sorry. I was going to say I don't object to removing them from the equation, but as Tony said, we can't just remove them from 2.4, the list of things permitted, because it says other articles used in connection with the outdoor consumption. So that's too broad and could keep them in. I think we need to explicitly say patio heaters are not permitted under this policy.
Okay, thank you. Is that okay? Is that clear to everybody? I wasn't able to hear some of that. Councillor Graham, are your questions answered satisfactorily so far?
Yeah, do you want to take a vote on that patio heater?
Yes, let's do that. We have. Do we have a second as well for that?
Hold on.
Do we have a seconder, please? For that?
Who's proposing? Am I proposing?
Yes, Councillor Graham.
Me, please.
Is anyone indicating to second? If you are, can you raise your hand?
Yeah,
Sorry.
Councillor Fulton McAllister, thank you. Okay, okay, so are we going to, is there any more discussion on that, or are we going straight to a vote on that, please? I think we've got the answer. So, Councillor Price, are you indicating to speak?
Yes, Chair. Obviously, you know, environmental concerns are highly important, and we all understand that patio heaters are, you know, detrimental to environment and air quality. What I would suppose is that the committee consider if we are in a second wave situation, if we are finding that businesses are having to close, already suffering a highly detrimental impact to their economy during this summer and spring, that we don't live in continental Spain, and to the ability for people to sit out in the colder months will be completely negated if there isn't a provision for some kind of warmth and heat, and it will have a serious impact on the viability of businesses to be able to offer outdoor seating if you take away the opportunity for them to have patio heaters. So that's more of an observation for the committee of the pros and cons of such an item. We know that there are cons, but to remove them immediately will effectively shut down these businesses if they cannot serve people inside. That's my view on the impact of it.
Okay, thank you. We have to, clearly, with all of these measures, we have to find a balance between what is going to help the businesses and our own concerns about the environment. I personally wouldn't wish to remove the patio heaters completely. However, I wonder if we can have a wording in the document that prevents them from being used ordinarily. David, can you come in on that?
Right, just trying to think of my feet on that one, Chair. You could add wording that is a presumption against grant on patio heaters, allowing you to reconsider it. You could have a presumption against grant except within certain months.
Yes. Yeah. I think that sounds
Sorry.
like a sensible suggestion.
So that would be a presumption against use except in certain months. A grant of patio heaters if asked for, but they're not expected to be used other than, and you'd specify the months.
Yep. Okay. So suggestions for months. I'll kick off with October to the end of March. Does that seem sensible?
I'll second
beginning of October.
Is that October to March?
Yeah, 1st of October to 31st of March. Okay, seconder for that, and then is everyone happy? Yep. Thank you.
Sorry, who was proposing the seconder on that?
I proposed that, and the seconder was.
I seconded.
Councillor Giles. Thank you.
Can I clarify what we're now talking about? That we are changing the wording of section 2.4 to under that fourth bullet point to say umbrellas, barriers and other articles used in connection with the outdoor consumption of food. Heaters, patio heaters will only be permitted between the 1st of October and 31st of March where applied for. Is that what we're saying?
Yes.
Yeah, we're applied
correct,
for.
Yeah. Yes. Yeah. Okay, Alex. Do we need to vote on that? Everyone has indicated. Would you like to have a formal vote on that?
Leslie's got a point to make on it as the proposer.
Thank you, Councillor Graham.
Thank you. I was wondering if we might also add where the temperature drops below a certain level, because you know, people can. I don't want patio heaters to become the default mode for 6 months of the year. I would prefer I would like them to be available as a last resort if it's not practical to put up a shelter or put on a jumper, so that they're not routinely used. They could just be used if the temperature drops below, say, I don't know, 15 degrees or something like that.
Okay, we have several people indicating. Who wants to speak on that particular point, please? Councillor Giles.
I was going to say, I think that would be impossible to administer.
I think in terms of conditions and enforcement, I think that would be impossible to administer because an argument over what the actual temperature we've reached. Councillor McCartney Gray, please.
Yeah, so if we did that, that would potentially exclude people with some forms of disability from actually being able to enjoy being outside in premises, because if the temperature drops too low, it's very difficult because of the levels of pain you have. Whereas if you do have heaters between October and March, then there is the possibility that someone like me might be able to go to the pub. Not that I'm going to the pubs at the moment, so.
Okay. Councillor Fulton McAllister, please.
I feel like I'm opening this up again, but there is Councillor McCartney Gray makes a very good point, and actually the temperatures can get very low between March and September as well. So if we are having cold snaps in that point, do we want to put in any provision for patio heaters to be used in the normally non-permissible months where it becomes on average across a week less than 15 degrees or something? I can see Alex's face, and I know that this is going to be, that suggestion would be impossible to enforce, but does anybody have any suggestions on that?
We are complicating matters significantly, and I don't think this is going to work. David, presumably within the document that we've got here, we've got provision to on individual cases. We've got provision here to make separate conditions applicable.
Not on the wording suggested, Chair. It wasn't a presumption. It was, as far as I understood it, that patio heaters were allowed only between 1st October and 31st of March. I mean, you can amend that to be woollier with the difficulties on enforcement.
Yes. Okay.
I retract my comment. Leave it at October to March proposal that I originally made.
Okay, so the proposal is as stated, where patio heaters are only available for use between the 1st of October and 31st of March. I will put that forward as a suggestion, and seconder, please. Okay, Councillor Fulton McAllister, shall we vote on that? All those in favour of that, please?
Can I just confirm, are you proposing that as a standard condition?
Yes, we are.
Yes, or and then the same change within. I think the Appendix 2 just refers to the paragraph, doesn't it? Or just refers to the policy. Yeah, no, paragraph 4 within Appendix 2 says the objects or structures.
Chair, you can just add it as a condition 21 if you like.
Well done, Dave.
Yes. Yes, let's do that. Add it at the end as number 21. Okay, all those in favour of that, please indicate. Okay, so that's me, Councillor Maxwell, Councillor Ackroyd, Fulton McAllister, Giles, and McCartney Gray, and Huntley and Oliver as well, please. And that, all those against? Thank you. And abstentions?
Who was against? I was listening for you.
Oh, sorry, no one was against, and abstentions is Councillor Price and Councillor Graham.
Thank you.
Okay, so right, let's move on to further questions. And I had Councillor Oliver on my list and Councillor Laura McCartney Gray. We'll have Councillor Laura McCartney Gray first, please.
Sorry, I was expecting you to go to Councillor Oliver. I have some questions around accessibility and a proportionate approach. It says the recommendation about issuing licenses. I was just thinking, how would we react to people with physical disabilities where there are tables on the pavement and they have to move onto the road to get past the tables, and not just people who use wheelchairs, also people who have visual impairment. Getting down into the road could be an issue. The other point I had was that we are changing the concern and conditions at point 4, paragraph 2 on page 23. We're changing the wording in that. I wonder if that could also be reflected on page 21, because at the moment it stands that the only people that we will take account of comments and representations made by, and we have a list, including Norwich Access Group, which is fantastic, and any other relevant authority. We've got nothing in there about residents either. So I was going back to Councillor Erin Filton McAllister's point.
Okay, so yes, can we add into that paragraph on 21 bullet points, the point that Councillor made about accessibility groups and residents? So do we need therefore a more exhaustive list of relevant authorities? David?
Any other relevant authority should give the necessary flexibility. Certainly it's appropriate to add residents, and apologies it's not on there already. Regarding stepping into the carriageway, I would expect that if an officer saw persons needed to do that, it would be unacceptable, except in the cases of pedestrianised areas. I mean, I'm not saying that one delivery truck a day should rule that out, but on a standard footway, your standard policy would make it unacceptable for any pedestrian or wheelchair user to have to move into the carriageway. That's a straightforward safety point. So I would expect when the application comes in, a competent plan is attached, making it clear that that is not going to be needed.
Okay, thank you for that, David. So the safety mechanism is in the wording already. Okay, Councillor Oliver, thank you for waiting. Please go ahead.
Hi, my questions have been pretty much answered. I had some concerns about heaters and also about the timing, so I was just going to ask around that, because just being very aware of people living in the city centre that perhaps, given our housing issues that are nationwide, don't necessarily have the choice to live somewhere quieter and been put in this situation through no fault of their own. But hopefully, I think we've achieved a good balance, so thank you.
Okay, thank you for that. Okay, right. I'll look around my screen again, and I can see Councillor Fulton McAllister with a question, please.
It's not a question. I just want to clarify that where we added the wording about residents being consulted, councillors were also now added as a result of Leslie's point. Has that been done? So that was on page 23, bullet point number paragraph 5, bullet point 2. we'd added wording after the word where.
Yeah. Yes, yeah, we had that down earlier, didn't we?
And councillors were in, and we are adding residents and councillors to that additional list on 21. Is that right?
I've just got residents, but we can add councillors into. Yeah.
My understanding that it was councillors as well. Okay, thank you. Right.
Yeah.
Any further questions? I've got a couple myself. I'll come back to you, Councillor Price, if that's okay. My question was also clarifications. And I have a question for David about how this particular tables and chairs license differs from the existing one we have, and what's the significance of paragraph 2.5 permission?
It differs. Oh, that's interesting, Echo. Right. It differs in the speed of the period for consultation, much shorter. It differs in the speed with which we have to determine it. It differs in that it's an automatic grant if you don't determine it, which is a really big change. It differs, I guess, in the expected amount of items that could be put on the highway. And otherwise, the legislation includes the assistance regarding the planning and street trading aspects to make sure those bits of legislation do not become a problem.
Okay, thank you. On paragraph 2.4 on page 18, where it lists the items that we put on the pavement. My question is about where it says bars, counters or stalls for selling or serving food or drink. Does that include bars that stock the alcohol within them outside? Did anyone hear that question?
I did, thank you, Chair, sorry. That's a very good point because, of course, it is not a licensed area. So if the technical phrase is, if the alcohol is appropriated to the contract outside, you'll be wanting the area licensed. I would not expect that to happen.
Okay, so do we need to be more explicit about the meaning of the...
I don't think so, because if somebody comes in with an interesting suggestion that makes it clear they wish to effectively run an outside business, the officers will be able to put them right.
Okay, thank you. I will come to Councillor Ackroyd now, because we haven't heard from Councillor Ackroyd.
It was just a clarification that I wanted, really, and it's something that Councillor Fulton McAllister mentioned earlier, and it's about the sort of clearing up time. So we agreed that the licence would be given till 10. So does that mean, and is it clear, that tables and chairs would have to be put away before then, or is there a sort of 15-minute after that time that you have to put things away? So I just wondered if that was clear in the policy. Thank you.
Okay, thank you. David, how does that stand at the moment as we've worded it?
It should be understood by the applicant that if you're allowed to put items outside until 10, that doesn't mean 10:15. It's not the use, it's the location of the items on the highway. So they need to start moving them in before 10 to make sure they're clear by the end of the permission.
Thank you.
Okay, thank you. Councillor Price.
Thank you, Chair. So I've got a quick question on the consultation determination period, but I would actually suggest that you know, customers and the use of the outside space, particularly as we've rolled it back an additional hour there to 10 p.m, should actually be able to use the facilities up until that time. And actually, you've got to build in a reasonable amount of time. I mean, I'm sure lots of us have done bar work and stuff, shifting loads of chairs and putting stuff away, and they've got their own tidying up to do in and around the premises. So there should be a fair and reasonable amount of time beyond 10 o'clock to pack away. So I would suggest that could even be up until 11 p.m. really, so that staff are not under undue stress to quickly pack away heavy furniture and stuff. But I didn't see was there clarity of the packing up, because David says it is understood, but it is not written there. So I think we should have an additional point that says that all furniture needs to be put away in a safe area, that it doesn't obstruct the highway, that they have to store it on their premises, and that they have a fair and reasonable amount of time to put that away, no later than 11 p.m. conclusion.
Okay, my understanding was that the original 11 o'clock was, it did include that putting away period. So what you're suggesting, Councillor Price, is to add a specific putting away period after the 10 o'clock?
That's correct.
26,
okay.
paragraph
Sure.
9.
Yep. Okay. Yep. See that. Thank you, Alex. I mean, I would just add to that. Then my proposal would be to add to that is fair and reasonable that packing up starts after the 10 o'clock finish use of customers for a fair and reasonable amount of time. You know, and that, yeah, store security is fine.
Okay, David, can you respond to that, please?
At the moment, it's easy to enforce. In other words, come 10, they will have been removed by that time. I, as a lawyer, don't like using the words reasonable because I can't enforce it. On the other hand, it's your discretion. If you want to add a reasonable period without them being used whilst they're packed away, but I just flag it will make your enforcement officers' jobs very difficult.
Yes, it will. And also, if using a reasonable time, that could be easily abused. And some of this furniture is noisy when you're putting it away, especially in large tables and chairs if people are using those. So we couldn't have that open-ended. And equally, Councillor Price is suggesting that a reasonable time might be longer for some than for others. So either we don't add this condition and require everybody to remove their tables and chairs by 10 o'clock, or we have a reasonable period such as half an hour, or we extend the time, as I think David is suggesting, extend the time from the 10 o'clock that we agreed earlier to something a little bit later. Thoughts, please? Councillor Fulton McAllister.
Thank you, Chair. Yeah, this is exactly why I actually made this 10 o'clock proposal earlier, because in reality, my understanding was people do need to have packed up by the end of the licence, which, thank you, Alex, for pointing out. I think point number 9 on page 26 suggests that that's when they begin packing away. So I think we need to amend point number 9. And to say that the objects and structures permitted by this licence shall be removed from the licence area each day by the end of the licence period, not outside of the licence period, and stored securely. And I would propose also that I don't know if other people's understanding in our previous vote was the same as mine, that we were expecting people to be packed away by 10 o'clock or 11 o'clock. But if that wasn't people's understanding and they were expecting places to start packing at 10, now might be the chance to say, so that we can amend that time. Because that's why I feel we should leave it at 11, but being clear that people need to be packed away by 11.
Okay, yes, that was my understanding from the beginning. Tony would like to come in at this point. I think that's a good idea. Thank you.
Thank you, Chair. I just want to clear up that what the intent of number 9, what that actually means. Whereas outside of the licence period, that doesn't mean that the clearing up should take place after 10 o'clock or whatever period we decide is appropriate for the end of the licence. It means that it's outside of the licence period, i.e. 1 minute past 10, everything should be gone. So if we're looking to build in some clear up time, then we would need to extend the license. What you remember is that this license is effectively a license to obstruct the highway, and it doesn't really matter whether the tables and chairs are being used at that time. It's a license for that business to have those tables and chairs out there. So if we're going to have an end time, that is an end time where it would be gone. We can't sort of in license plus a bit. That makes sense.
Okay, thank you, Tony. Right, so we're left in a position where either we have to leave it as it is and request tables and chairs to be removed by 10 o'clock, or extend that, go back to that point and extend that to a later time. Councillor Maxwell has wants to make.
One of the reasons that we had it reduced it down to 10 o'clock was because of the noise nuisance. And I understood that they would have everything packed away by that time. I don't know about anybody else, but it is a really noisy business, especially when we've got those barriers there. But so I think it should remain, or alternatively allow 15 minutes to clear it. They're not big places, so we could have an additional 15 minutes for clearing away.
Okay, Councillor Price, a quick point, please.
Yes, thank you. Yes, when we were rolling it back earlier, I did not understand that. I had misunderstood that. My thoughts have always been that it's very proportional to have a crowded area up until 10 o'clock, and actually, you know, working in bars and stuff. That we're really talking about 9:30 is going to be the end, and that's going to have a detrimental impact. The role of the committee here is to be fair and proportional, and to balance the needs of the business with the needs of the residents. And normal closing time for pubs, etc., is 11 o'clock, and there is always a hubbub. And if you do live in a city centre, there's general noise of people moving around and stuff. So there is an acceptable level of noise of out on the streets already, up to 11:30. So I would suggest that we either roll back to 11 o'clock, so that we can actually have people properly accessing the space until at least 10 o'clock, or as a compromise, we could potentially go for a 10:30 number. And I think that, you know, it would be quite logical that businesses would stop people being outside at about 10 o'clock to give themselves that 30 minutes of pack up. So I would like to change the 10 o'clock to at least 10:30 and possibly back to 11 would be my suggestion.
Thank you. Personally, I'm in favour of the original 11 o'clock with this understanding that we have the everything put away by then. David, could we add a condition where it is 11 o'clock on certain days, such as Friday and Saturday, 10:30, as Councillor Price has suggested, Sunday to Thursday?
Yes.
Okay, so that is what I'm going to propose.
I'll second that.
Okay, thank you, Councillor Giles. All those in favour?
Ian, before you go, can I? Okay.
Yes, please go quickly.
Sorry, I wanted to just make an additional suggestion, because I think we are talking that I do think we need to change that word outside, because it is ambiguous on point 9. So my proposal earlier on to change that to clarify that blah 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 shall be removed from the licence area each day by the end of the licence period.
Yes, thank you. Let's include that in that proposal, and seconded by Councillor Giles. You still in agreement with that? Okay, let's have a vote on that. Alex, do you have anything to say before we do that?
The one that you're proposing, Chair, you're saying what, 11 o'clock for a Friday and a Saturday, 10:30 every other day?
Yes.
And the word changing from Erin.
Which is just adding in by, isn't it?
It's removing
It's removing the
outside,
word outside.
so
Each
it
day.
reads, shall be removed from the licensed area each day by the end of the license period and stored securely.
Okay, thank you. Councillor Oliver, do you have a point to make on this proposal?
Yes, I just wanted to clarify. So if we're going to the new times, then you know, there's nothing to stop people, as it's a bit quieter, hopefully at the end of the evening, coming inside and having a last drink or whatever, is there? We're not saying to people you have to leave the whole premises by this time just because they're sitting outside. I'm just wondering how it will look. And no, it's just that when you have an area like St Benedict's as opposed to other less residential areas of the city that might have just as many premises, do we still have the flexibility as well?
We have the flexibility to change the condition for each individual application.
Yes.
So if residents say it's too late on this street, we can change that.
Okay, thank you. Thank you.
Okay, thank you. Okay, let's go to the vote on that. So all those in favour of that proposal? Okay, so that is everybody except Councillor McCartney-Gray, I believe. So all those against? And abstentions? Councillor McCartney-Gray.
Thank you.
Okay, thanks. Any further questions? I've got a final one for David. Earlier in your presentation, you made some suggestions from yourself, from your legal point of view. Have you indicated those to Alex, and do we need to discuss those right now?
Alex was copied into the email yesterday.
Is it the Appendix 2 changes you're referring to?
I'm happy to go through them, Chair, if that would help.
I think if we can do that quickly, so that we, because we're going to move to the vote, I think, quite soon. So I think we should go through those quickly. Councillor Price, do you have a point on that first, please?
Well, I just have my final questions, Chair. It's just basically around the consultation period and the determination and the non-determination. So my concern is that because of the shortening of the window, and we have certain consultees, and I'm particularly thinking of the accessibility and the police here, is that because as all organisations are under tremendous pressure, resource pressure, the shortening of the window may mean that although they may wish to have raised some kind of objection, that there may not be an opportunity for staff to have actually addressed that in time. And then that thus gives a presumption of consent. And so my concern is that there needs to be a reply from the organisations, even if it says no objection. But to just say, right, well, there was nothing raised in the 5 working days. That's an acceptance from the police or from accessibility organisations or the fire service or whatever. I think is wrong, because effectively the people are under pressure. So that's one point. I think that there should be a reply of acknowledgement of the receipt of the application before it's actually assumed that that is an acceptance. My second point is that the non-determination, this bit I did not understand, where he was saying that if there is nothing being, that it effectively says that officers don't need to make any determination on it. So an application can come in, and that if they don't raise the issue at all with the chair or vice chair at all, that then it is just completely accepted. So is that the case for objections raised that are raised? It will definitely be consulted upon by officers and the chair stroke vice chair. And does it also mean that officers, if there is no objections, are effectively free from making any judgment about it? Because that's how I interpret the ruling.
Chair, do you want me to respond?
Yes, please.
It's a fair worry, but I think we have in the wording on page 24 covered the point. I mean, let's suppose somebody puts in an application, for whatever reason, none of the statutory authorities or the public respond with concern. However, the officers are still able to themselves decide there is a concern. The obvious one is the entire footway is covered and somebody's going to have to step into the carriageway. You wouldn't expect your officers to grant that. So that's the sort of thing where I would expect the second para to kick in and the chair or vice chair to be consulted. I'm afraid if we hear nothing from an organisation, the limited period we've got for consultation means we must proceed on the basis of no objection. It's unsatisfactory because I'm fully aware of the resource implications, but I can't see another way of doing it.
Thank you, David. We have a similar situation, don't we, with temporary event notices where very short time is allowed for.
Yes, indeed, Chair.
Consultees. So we're going to have to, because the government have imposed this upon us, we're going to have to work within this policy wording.
Chair, can I just note that I am disappointed that is the situation, and I would like to stress that officers make every endeavour to make contact at the very outset with any of these applications with the relevant bodies. That is not just a simple single email sent, that a telephone call is made, a follow-up effort is actually made to try to get some engagement.
I would, yes, I would second that myself. I think it's an important point, and we should endeavour to have as much feedback as we can from the consultation.
Yeah, just it might be worth mentioning at this time. It's very difficult to get hold of people on the phone, and we are all using email as officers. So unless you're going to have to prescribe exactly what you'd want done there, I think that would be a challenge for officers.
Clearly, in current times, and basically this is why we're here, it is going to be challenging to officers to follow these calls up, especially as we're likely to have a number of applications at the same time, so officer resources will be stretched. However, I would advise all councillors and members of this committee to keep an eye on the applications that we have, sign up for the email alerts, and then we, as representatives of the public, can make those representations and therefore cover some of the work that might be done by other time-stretched organisations. So hopefully we can do our bit there. Okay, Councillor Fulton McAllister, I'll come to you in a moment. Councillor Graham's had a hand up for a while.
Thanks, Chair.
Sorry, Councillor Fulton McAllister. I'll come to you in a moment. I'll have Councillor Graham first. Apologies.
Thank you. I was going to suggest a way of slightly mitigating the time lag, the lack of time, and also the workload of officers is when we send, is if we tell them right at the applicants right at the outset that when they make their application, they also have to copy in the consultees, and we give them the contacts so they can do that. It takes one step out of the process and one less thing for officers to do, and also increases the likelihood of consultee engagement.
Okay, is that a practical suggestion, Tony or Alex?
Sorry, I'm being Tony because he's in the same room with me. No, no. As the licensing authority, we're responsible for that contact. Okay.
Right. Thank you. Right. So I'll go to Councillor Fulton McAllister, and then we better wrap up. I think after that, unless there's any urgent questions that we've not covered. Erin, please.
Thank you. Fully appreciate your concerns, Councillor Price, Councillor Graham, and it is a problem, but the legislation means that we can't really do anything about it, which I think is why it's going to be so important to have that enforcement process in place. That yes, we might not be able to object and consult properly before granting, but if it does create those concerns, if those concerns do materialize, we are able to act on them. So really we need to be encouraging people to report anything bad that's happening as a result, and then taking action, that side of things. I don't see that we have a lot of options otherwise.
Okay, thank you. I think in summary, we have a number of safety mechanisms in this policy in order to ensure that the council can scrutinise all applications and to ensure that everything is that. I mean, some of our biggest concerns have been around access for disability groups, noise for residents. All those things are covered, I believe, in this. I'm looking around and I believe people can't hear me. Is that correct? Okay, I'm going to propose now that we go to a vote, and the recommendation is.
I'm losing you.
Okay, is that better? Okay,
Chair,
okay.
I don't know whether you wanted me to go through that list. I flagged it earlier and it's sort of fallen off the table a bit. It's quite short.
It has, David. Please, please proceed, and then we'll go to the vote.
To very quickly summarise my suggestions on the draft report, page 18, para 3.1, I was just flagging the need to ensure there's a clearly marked area of the highway being sought.
Thank you, yeah.
I think there's hopefully common sense ones. Same paragraph, we're looking for written agreement from the owner or occupier, and that's where you drift onto someone else's frontage. And I was thinking getting both the owner and the occupier, if they're different, might be quite a task.
Yeah.
Para 3.5, one of the jobs will obviously be to consider whether the area of highway sought is appropriate highway, lawful highway for this pavement licence. Page 23, para 5, third paragraph down, a few words were missed. Instead of the authority can take action to cover any costs, I suggested the authority can take the steps itself and can take action to recover the costs of doing so. That's where somebody's breaching their licence. We give them a notice saying basically sort this.
Yeah, okay, thank you.
Only two more points.
Yep.
I mentioned in Appendix 2 conditions, condition 4, instead of used for the purposes stated above, as there are no purposes stated above on that page, I was suggesting the purposes specified in the licence. And the last one, Appendix 2 condition 7, should mention clause 14 instead of clause 13, and I think it's useful to add, or early termination of the licence under section 6 of the Business and Planning Act 2020. That's a lot.
Thank you very much for that, David. So Alex, shall we take those all together and vote on those all together to go into the document?
Unless anyone's got any questions, take them all together, absolutely.
Yes, any questions or comments on that? I can't
should we just confirm, Chair, what we the changes we agreed as a committee as well, just to refresh everyone that it's all in? No, okay. Alex says no.
I'm surprised.
I hope that they're all duly noted correctly. We'll watch back on the video.
They've all been listed, and anyone that wishes to go back to the video can do that. Even the chaotic start. Right, can we therefore vote on those conditions that David, or amendments that David has suggested, and then we'll go to the final vote. So first of all those conditions taken as one, everyone in favour? That's unanimous.
Oh, well done. Perfect.
Thank you. Okay, so finally then the recommendation is that members adopt the pavement licensing policy attached to Appendix A, including the amendments that we have agreed today. Okay, all those in favour, please. And again, I think that's unanimous.
Lovely.
Thank you very much, everyone, for coming today. And apologies to those watching on the internet and members present.
Chair.
Technical problems. Yes, Alex.
Yeah, Tony just wanted to say something before you close. Hold on a sec.
Yep. Thank you.
Yeah, thank you, Chair. It was only really just to say that we have had, I think, 14 applications already, the first of which expire tomorrow. So Councillor Fulton McAllister and Councillor Stootley expect a barrage of stuff from me or my office over the next few days.
Yeah, thank you. Excellent. I will look out for those from my Yorkshire retreat and come back to you. Okay. Again, thank you.
Chair.
Councillor Graham.
I just wondered if it would be appropriate to send that barrage to the rest of the committee so that if we want to comment to the chair and vice chair, we can.
They should be on the licensing pages on the councillor. They've done the licensing website now.
There is a list of current applications in that everyone can access. So I recommend that everyone here does that. And if there's any of your colleagues in your wards that you'd like to forward to, do that and see if we can get a full response. Councillor Giles, did you have a comment?
Yeah, I was just going to ask about thoughts on timings moving back to physical meetings, perhaps in the council chamber, given the technical difficulties we've had today. I mean, if this was a subcommittee, you know, with the technical difficulties we've had today, it would have been pretty bad. Surely we can socially distance in the council chamber.
Absolutely. Today has been technical problems have been probably the worst we've had so far. We did have a subcommittee last week. We realised that to council because of similar issues. Ideally, we would meet in the council chamber, but at the moment, I don't think the current legislation allows us to do that, or current guidance allows us to do that. And we should only do that when it's safe for all of us to do so. A lot of these Zoom meetings have been very successful. This one was rather chaotic, unfortunately. Hopefully the next one will be better, and the next sub, we've got sub next week. Any further comments before we wrap up? Erin, please.
Yeah, can I just highlight that it is not about keeping the council safe while putting everybody else in danger. It's about restricting the number of people in City Hall as far as possible, because us going in puts officers in danger if we don't need to be there. So that's the priority, is keeping everybody as safe as possible.
Yeah, okay, thank you for that. I think we will have to persevere for the foreseeable future. Next week's subcommittee is a Zoom meeting. Okay, thanks again everyone for coming and bearing with us, and this meeting has finished.
Okay, thank you.
Thank you.
Thank you.